Everyone, hope you're doing well. Welcome to Chapter 3 in your Pearson textbook. All right, lots of great information in Chapter 3 related to legal system for healthcare professionals. Much of what you've heard about already, but we'll go through it and get some great information for you. Feel free to take a look at the learning objectives when you get a chance. Lots of great information in here related to what we're going to go over today in this lecture. Medical Practice Acts. Some of the things that you want to really understand in regards to medical practice acts is they're established by state medical boards and they provide a baseline for medicine in the state that they're operating in. Some also things that are different from state to state. There might be differences in regards to licensure. I'll give you an example. Some nurse practitioners in some states can hold their own panel in primary care, and in other states they're used more as extenders, which is something that I'm passionate about personally. We don't have enough primary care nationwide. Why not allow nurse practitioners to have their own panel and manage their own patients? But there's different variations from state to state based on medical practice acts. So that's one example. Physician licensure, of course, occurs from an examination standpoint through the National Board of Medical Examiners, the Federal Licensing Examination, and the U.S. Medical Licensing Examination. So they have all these acronyms here. And then you have an endorsement and approval or a sanction. Sometimes they can be sanctions based on maybe there's a negligence case, that would impact their licensure at times, a variety of different instances. But that's a little bit about how physicians are licensed. Okay. Next slide. And we got about probably 20 or so slides we got to get through in this chapter. Okay. So reciprocity in regards to cooperation from one state granting a license to another state. That happens at times, not always. Depends on the relationship between the states. And then registration, you have to be annually or biannually registered and pay a fee in order to practice in the state. All right. And you got to get CME, right? You got to continue your education because healthcare changes. That's one of the requirements. You have to stay up to date with different changes in healthcare, and CME is a requirement. That's why a lot of physician contracts have CME as a part of that. So does our APP roles as well. All right. When a valid license is not needed by a physician when they're employed by a federal medical facility, it's an emergency or a while in a residency, right? So we have a family medicine residency where I'm at currently, have oversight of that, and they don't have their licensure yet, but they're able to act in that residency. They have graduated from a medical program, right? They went through school, but they're going through residency in order to be ready to have their license one day. All right. When I mentioned in regards to licensure for residents, one thing that's a little bit different. They have a medical license, but it's a postgraduate training license. It's not a standalone license, so they have to have supervision. So that's why it's a little different. They can still practice, but it has some guardrails around it, right? You can, of course, be suspended from your license based on unprofessional conduct, commission of a crime, Medicare, Medicaid fraud. Not everything would suspend your license, but a lot of things can in the personal incapacity, right? Physical and mental. Things happen at times where we need to examine that on a national and state level. All right. So there's, of course, licensure and certification for our allied health professionals. We talked a little bit about that. They're varying depending on the role. And then there's also accreditation, right? So accrediting agencies are a little bit different. That oftentimes is from a hospital perspective, like the Joint Commission accredits hospitals for, high standards of care. That's not a requirement for hospitals to function, but it's an extra incentive in regards to making sure that you're performing at the highest level. There are accredited bodies for state operations and for federal operations, like CMS will come through and survey hospitals in order to make sure that they're functioning at the capacity needed in order to maintain their accreditation. And I don't think it's called accredited. In order to maintain their status and bill for Medicare and Medicaid is what I was trying to outline. So Joint Commission is a little bit different. It's not exactly based on an individual provider. It's more based on the facility. One thing that I'll highlight, standard of care is really critical. You're going to see this in a lot of test questions. It's ordinary skill and care that must be used by medical practitioners in order to have a reasonable and prudent action, something that a reasonable and prudent person would do in that given situation. If you go outside the standard of care, that's where potential negligence and malpractice can happen. So standard of care is a really critical term when we examine things from a healthcare perspective. All right, so just some preconceived notions in regards to physicians. They're not required to treat people and everyone in a case of an emergency. So, they are protected by Good Samaritan laws if they choose to do so. But there's certain instances where, maybe they're not comfortable, don't have the training to do so. So keep that in mind. They are expected to use reasonable and ordinary skill to care for people, not extraordinary, not to perform miracles by any stretch of the imagination, and they're expected to exhaust all resources available to them to provide excellent patient care that would be ordinary and standard in any sense, like we talked about before. They don't have to expose themselves to risks to protect others, although many of them would choose to do so based on the Good Samaritan protection, etc. All right. Okay. A prudent person is kind of like the standard of care, but it's also a reasonable person, reasonable standard, must be able to form the following. Must be able to inform patients of the following: their diagnosis, their risk, and their expected benefits and treatment. So, sometimes when a doctor walks in a room, they'll go over the diagnosis, what they expect, the risk is the pros and cons of each decision that's made, and the benefits, of course, which would be, of course, the pro. So from that perspective, that's what a prudent person rule stands for, and that's what physicians or providers are required to do, the reasonable person standard. So take a look at that. Make sure you understand that and read it in the textbook. The textbook will probably explain it a little bit easier than I did, but this is the basics regarding the prudent person rule. Some of the things that I also want to mention, and not every situation is like this, because sometimes there's only one treatment, but they are also required to talk about different treatments, prognosis, cost, expected pain. The physician's not going to talk about costs per se, but medical staff will have that information. And then acceptable standard of care. This is what my recommendation is based on standard of care, and this is what has been practiced before. Those are some of the things the physician, or I'd say physician, it could be an APP too, so the provider would talk about in that given situation. Confidentiality in HIPAA is really critical. We don't talk at length about HIPAA in this slide show, but there's some great information here about confidentiality. The physician and APP, anyone in healthcare is required to keep things in confidentiality based on Medical Patient Rights Act. So patients have, of course, a right to privacy and respect for their records to be held confidential, and we'll talk more of this in length when we talk about HIPAA, but just know the basics surrounding that. Really important to know about the statute of limitations. This is a critical law. If a certain amount of time has passed before or after a crime has been committed, you can't charge someone, say, for petty theft a certain time after the act is done. And that protects both sides, from pulling kind of frivolous criminal actions against people when evidence is hard to come by and it's been done a long time ago. However, there are some rules related to evidence if there's new information gathered, and there's also some some criminal actions that don't have a statute of limitations depending on the state. A lot of this depends on the state. So be sure to understand what the statute of limitation comes with. And for healthcare related issues, it's usually 1 to 3 years. The discovery rule begins when the problem is discovered, right? Or the patient should have known about the injury. But if the problem is discovered, 10 years back and they're wanting to have a lawsuit now, that's not something that's usually going to stand in court based on the statute of limitations. So make sure you understand the statute of limitation. You can understand it from beyond just healthcare as well. I talked about Good Samaritan laws as well. No one's required to provide aid except in Vermont. Vermont has a requirement for providing aid. And this is not something I was aware of prior to reading this PowerPoint, which is really interesting. So providers are required to provide aid in Vermont, but no one is required in other states. But the Good Samaritan laws do protect them for providing care. So example, if like someone has a car wreck and a provider gets out and tries to perform CPR on a patient at that time or a victim, and he has a mistake and cracks the sternum or something and injures the patient, and the patient ends up dying because of it. But it wasn't due to the fact that there was any negligence. The provider was trying to save them. That Good Samaritan laws would protect that provider in that instance, and they would have to go through, of course, legal proceedings. But that's what Good Samaritan laws are in fact there for, and that's just an example that I made up. Respondeat superior means let the master answer. It means the employer is liable for the acts of the employee within the scope of employment. So if there's a hospital or healthcare setting that hires a physician that's had a lot of bad things, negligence cases in the past, and they ignore that, hire the physician anyway, and the physician causes negligence in the healthcare setting, and they're sued, the employer would be liable based on the respondeat superior clause on the legal side of things. So understand what that means and understand the basics surrounding it. Employees also have a duty to carry out orders. You have to interpret and carry out orders and then decline orders if they don't appear necessary or appropriate for the patient, and of course notify the physician. So that's one thing that we really highlight in our medical setting that I work at. We want to make sure that we all speak up for safety, and that doesn't mean that we're questioning everything the physicians or the providers do, but also if there's an issue that stands out, it's required of you to bring up that it's a safety issue, and if not, carry out the order as seen. Scope of practice. You guys know about this, and I'm going to go through these next couple of slides pretty quickly, but you have to understand your scope of practice and not act outside of that. And that, of course, is based on licensure and requirements for your role. Like an RN is not going to be able to prescribe medication, as an example, without a standing order or something similar. So, and really, RNs never prescribe medication. There's not really a standing order that protects that, but they can give vaccines with a standing order, as an example. But from that perspective, you have to follow scope of practice, and that's just one example. And then employers also have a duty to employees to provide a safe environment where they have the resources needed to protect themselves and their patients. So that's just a common practice in healthcare today. Risk management, these are broad terms. There are risk management departments in hospitals and healthcare settings that protect patients and providers from doing things that are outside the scope of their work, and also making sure they have the tools to be successful. They identify risky behaviors and practices, so something that's critical for success in the healthcare setting. And there's also incident reports in the hospital setting where if there's an incident, you report it, goes through a panel and is reviewed to make sure that we do something better in the future. And that also happens on a federal and state side at times too, when there's an issue or incident outside of the scope of the healthcare setting and review. So keep that in mind. That was pretty much all of this really great slideshow. So be sure to take a look at the slides yourself, take notes, read the textbook, and then when you supplement this with additional lectures and supplemental videos, you're really going to understand Chapter 3, Essentials of the Legal System for Healthcare Professionals. Reach out to me if you have any questions. Always happy to help. Keep up the great work. Thanks so much.